Mr Hack.
My lady, we haven't been able to find any authority which supports the property about changing of time. I think that the best we can do on the cases that we have is say that in Hall itself, the court could have said that it was not bound by the previous decision of the House of Lords because of the practice direction, the 67 practice direction. And instead what it said was that it did not feel it was bound by it, or the previous decision wasn't wrong because of the changing of time. But of course, taking my lady's point, it was a House of Lords decision. Ironically, we haven't found any House of Lords decision which is on this particular point about solicitors. But I think this court is then bound by Wallersteiner, which was Court of Appeal. So again, in principle, I think that if I'm wrong on the general point, then Wallersteiner would bind this court.
And Sibthorpe, but that...
Sibthorpe was Obiter, because it didn't...
That was Obiter.
Yeah. So Sibthorpe dealt with a completely different issue about CFAs. But Wallersteiner, we think, is the only Court of Appeal decision that cited any of these cases which actually directly deals with the point.
Yeah.
That says, as far as I can take that point. Your ladyship will have the references about public policy not being changeable over time and that there's lots of references to that effect in Sibthorpe. So if it is the case that this court can't go beyond Wallersteiner, then that will have to be the case. But the authorities certainly support the fact that public policy has changed, and in particular in relation to Sibthorpe, there are multiple passages. If I could, actually, I might just take you to a couple of them, if I may. So Sibthorpe is divider 20, starts at, in my law reference, page 289. Thank you. So I should say, for completeness, paragraph 40 of Sibthorpe, that's at page 300 in the electronic bundle. It's 2123. That's a reference to Wallersteiner there, which I think is what binds the court.
Yeah.
But then
Howard's case, that was Court of Appeal, wasn't it?
Yes.
Yeah.
Yes, it was a, I think that's probably also over. So it's a very different point on Howard's.
Yeah. Okay.
But Wallersteiner is probably enough for the court. Paragraph 49. Is the so it's certainly in Sibthorpe is a slightly different point. In Sibthorpe, the local authority, the claimants were indemnified against adverse costs by the solicitors. So the question in Sibthorpe was whether that extra indemnification provision was champitous or not. And on the facts, the Court of Appeal, Lord Newberg, Master of Wolsey's said it wasn't champitous, so the rest of it is technically obiter. But paragraph 49 talks about the importance of access to justice, and the shift in legislative policy towards favouring the relaxation of the previously tight ethical constraints in order to enable a variety of more flexible funding arrangements. And Lord Newberger quotes Lord Justice Danckwerts in the Hill case that the area depends upon the question of public policy, and public policy must be alterable by the passage of time.
Yes, but you do need to read the sentences before that.
Oh yeah, no, absolutely. It is one thing to say in relation to contracts with those conduct litigation, the breach of chancery should not be curtailed. It's another thing to say in relation to contract law chancery should be expanded. Yeah, we're obviously asking it to be curtailed. But that I was going to take you to paragraph 51 after that, which makes the same. should accede to the argument, it would be inappropriate in the 21st century to extend the law of champerty. Some force in the argument that economic logic supports the case for condemning the indemnity as champerters. However, the rule against champerty is not entirely logical in its extent or limits. Judicial observations strongly suggest that champerty should be curtailed, not expanded. And given that champerty is based on public policy, it's hard to see how arrangements such as the indemnity, at the very least in connection with litigation, are against the public interest or undermine justice. So I say we are in that type of territory in my submission. And what the judge has effectively done is expanded champerty, or looked at champerty in a different light to those which are traditionally has been under the lens of champerty. A similar point a lady has made in the Whittington case. I won't take you there, but that was a case which concerned the expansion of public policy, and of course we're not looking at that. We're looking at the contraction of public policy in line with the trends. The third point was in respect of the DBA, and I think, my lord, you're right, that under the terms of the DBA, the more that Candey spend in irrecoverable costs goes off the bottom line of the client. So in effect, there is a change of position between under the assignment, as compared to the DBA. The counter argument that I have to that are the ones that I touched upon before. The first being that it requires two things. It requires a solicitor who is deliberately acting in a way which is unprofessional and probably amounts to misconduct. If the solicitor deliberately takes bad applications and just inflates the amount of work necessary to do. But secondly, there is a control mechanism, and it's one that your lordship has identified, and it involves Mr Farrar, or whoever it would have been in that situation, going to court and saying they've acted unreasonably. It must be an implied term in the assignment that they can't just spend millions and millions of wasted time and costs for nothing, and I have to bear the cost of that. There must be some kind of reasonable implied term there in the contract of assignment. So,
well, then you'd have to imply a term, and it may not be easy to imply a term which can be readily applied where solicitors are not acting as solicitors. They're acting in their own interests with no duties of care. What's the context for deciding what's reasonable when they have their own interests in pursuing and winning the action?
I understand, and it may be that the intra-parties assessment gives an indication of what is reasonable inter partes in this situation. But it is I'm putting it forward as a possibility, because if the situation that we had, if Candey were to be permitted to run the case under the assignment, and then the inter partes assessment would have been £200,000, say, as a reasonable figure, but in fact the bill they put in was £1 million, which had been cut down. The question would then arise whether or not that difference of £800,000, the recoverable amount, then comes off the amount which goes back to Mr Farrar. And that, I would say, would be subject to some test of reasonableness. I haven't formulated it.
I say that they won't even provide a bill.
No, but Mr Farrar would receive nothing. And Mr
Farrar will have to somehow mount a claim that the fees were unreasonable, presumably obtain disclosure, avoiding a fishing argument, and then have some expert evidence as to the fact that these fees are outside the scope of whatever implied term there is limiting the amount that can be charged.
Yeah, so something like that.
It's a pretty horrendous exercise.
Maybe, but if the starting point is the inter partes assessment, or the party assessment was, say, £200,000, and Mr Farrar received nothing because Candey says that the bill was £1 million, and so we're going to take that off, So that I think it'd be quite reasonable for Mr Farrar under those circumstances to say, well, I'm not just fishing for this. They spent £800,000 more than the other side have been needed to pay. So something has gone wrong here. If they have acted unreasonably,
Well, you've given a pretty extreme example, but
yeah, I have.
the situation is where they've deducted the whole 50% cap, but the costs are taxed out at a somewhat lower level. And would Mr Farrar or his estate even be entitled to see any of that?
They wouldn't receive any money under those circumstances. But then they would question why.
They wouldn't receive any money.
No, if there was a huge disparity between the two, then that disparity would come off before the 50% went back to Mr Farrar. So Mr Farrar would say, well, I've just won £1.3 million and I'm getting nothing. That's because you have spent £650,000 on your fees. And I'm getting £650,000 plus whatever I come back. So if I got £200,000 recovered from the other side, and Candey said, oh yeah, you're getting nothing because our bill is £850,000, that's why you're getting nothing. I think in those circumstances, Mr Farrar would have very good reason to come to the court and say that Candey have acted unreasonably or irrationally. I mean, even if it's if it's a duty to act rationally under those circumstances, or not to act under, again, I'm just kind of thinking on my feet here, but the kind of duty which might arise, the kind of contractual duty which might arise, maybe simply that they have to perform the contract reasonably. And if they act unreasonably by incurring costs of £850,000 where only £200,000 were due, and with that claim were to be brought to court, then it may well be that...
I may have misunderstood this. I thought the way it worked was that Candey's recovery, their fees were effectively capped at 50%.
They are, but as I understand it, the costs come off first. Is that right? Can I just take this?
So they get their full costs.
The costs are capped at 50%. Yeah.
Costs are their recovery.
Yes.
I mean, that whole idea
Yes,
of
yes,
this is they don't get more. They don't get more than they actually earn in fees.
Yeah.
Otherwise, we really would have a
No,
problem.
we're not going to go there. No, absolutely.
Yeah.
But the point is, I was agreeing with you to this extent. I think there's an adverse effect on Mr Farrar by entering into the assignment as opposed to the DBA.
Yeah.
But what I was saying is there might be a control mechanism to actually mitigate the effects of that. I can't really take it much more than that. But one also must bear in mind, of course, that in that scenario where you have the assignment, Candey are taking the adverse cost risks as well.
Yeah, just on that point, I mean, of course, as we established this morning, the effect of 3.1b is not that there's actually a cap of 50%. The 50% cap only bites after the ATE, which is one thing, but also after the deduction of the sum of £125,000.
Yes.
Is there anything in the evidence which explains what the £125,000 was for?
I don't believe so. No. Okay, I'll take instructions. I've got no evidence at all to say that, unfortunately. We think we know, but... so that was the second point on the DBA. I've got one more point, but I'll save it.
Sorry, I'm still a little puzzled by this because one of the things that I think I was struggling with this morning was, and I'm still not quite clear about this, and it may be because I'm being dense, is from what is the sum of £125,000 being deducted? It's always the problem when you've got negatives.
And
So, I mean, presumably it can't be the case. Yeah, let's take the ATE premium. it can't be that doesn't mean that isn't paid. Surely that what it means is it comes off the top.
Yes, it does.
And therefore, presumably,
That's it,
the 125 comes off the top as well.
Yeah, that's right. Yeah. So the 80, basically the 80 premium, for the purposes of the maths, the 80 premium and the £125,000 could be treated the same.
They both come off the top.
Both come off the top.
Yeah.
And so that would then be, if there's a £1.3 million, you would take off the 80 premium, then you would take off the £125,000, and then you would 50%, then you get 50%, and that would be the maximum recovery. And that must be right.
But if the 125 comes off the top, what happens to it? That's what's so mysterious.
Yeah.
We know what happens to the 80.
Well, everything goes back to Mr Farrar. So Mr Farrar would get it because Candey can only retain its fees, and then 3(1)(c) says any balance. I suppose the argument is does the balance include £125,000? But I suppose it must do because the only party who's retaining anything after the assignment is Candey. Candey are at 509,100. 80 goes back. And then everything else goes back to the assigner. So Mr Farrar would get back the 125,000. Right?
Yeah, well, that's certainly the way the calculation that we looked at this morning works. I can see that.
I suppose you're asking the question, why is it there at all? Because you could have structured this in a different way that you didn't need to have the £125,000 expressly there, and just left it as well. Candey. So Mr Farrar, for whatever reason, gets £125,000 back separately.
Yeah, I mean, you see, if that was the commercial intention, one would have thought the way you would do it is you say, okay, the order of distribution is as follows. First, the AT premium. Yep. Secondly, 125k to Mr Farrar. Thirdly, the fees capped to 50% of the recoveries. And then if there's any balance, then to Mr Farrar. That's what one would have thought would be a logical way of structuring it. But that's not what it says. I appreciate your submission is the effect is the same.
The effect is the same, but I agree. There obviously was a reason why for restructuring it, but the effect is the same, that Mr Farrar gets the money and Candey don't.
Yeah, all right.
Right, you've been under a lot of friendly fire, Mr Hack. Where are we?
Thank you very much. I had one other point, but I'll wait a second for reply. So if that's all right.
Well, if you want to make it now, I'm not stopping.
We'll wait to see how I'm done.
All right. Thank you very much. Yes, Mr Cohen.
Thank you, my lords. I propose to proceed in this way. 5 points, 5 headlines, if I can put it that way, and I intend to try and finish about 3:30, 3:45, if I possibly can. I hope I will. Just so you have the headlines, first of all, a very short introduction. I know the territory is by now very familiar, and you have quite a full skeleton from me, but just a short introduction. Secondly, I want to deal with what lies behind the public policy rule preventing solicitors from having an interest in litigation. And I particularly want to pick up a point made by my Lord Justice Phillips about whether it's designed for the protection of the opposing party or for the protection of one's own client. And there may be some distinction to be drawn between assignments and other types of fee arrangement. The third point I want to make deals with statutory modifications, in other words, non-compliance, contingent or conditional fee agreements or agreements analogous to those. Are they an answer to this appeal? The fourth point I want to make is, can this court reappraise the public policy reasons for prohibiting solicitors from having an interest in litigation? And then the fifth and final point is, even if you can, should you? And if I could start, please, with a short introduction. The first ground of appeal, ground 2.1, asserts that the judge below applied a test of whether the assignment improved, I should say, access to justice. But in fact, what the judge ought to have done was applied the Trentex type test of whether there was a genuine commercial interest. In fact, the judge did neither of those things. What he found is that there was a bright line rule, so that there could never be the assignment of a cause of action from client to solicitor who was acting for that client in respect of particular proceedings. That's one aspect, judge found, of a general public policy which prevents a solicitor from having a personal interest in the litigation in which he or she acts. And the only exception to that, of course, as we all accept, is where statute has intervened, so that there are permissible CFAs or DBAs. The rule that a solicitor, the public policy rule that a solicitor can have no personal interest in litigation in which he or she acts, seems to me to date back to about 1784 or possibly earlier. That's the first of the authorities that we've given to you in the authorities bundle. So there or thereabouts 250 years. And since then, that rule has been expressed in numerous authorities, both first instance and on appeal. In respect of the decisions of this court, so far as I can see, there are the following. There is Pittman in 1896. There is Wallersteiner in 1975. Trentex in 1980. Giles in 1993. Awad in 1999. Factor Tame in 2003. Sibthorpe in 2011. And Rees in 2015. And of those 8 decisions, 5 of them are directly concerned with solicitors. And it is, I say, the ratio of Pittman, Wallersteiner, Awad, Sibthorpe and Rees that a solicitor can have no interest in litigation in which he or she is instructed. And the only reason we've not given you the earlier authorities is because there are liberal quotations from them in both Sibthorpe and Rees, which are the 2 most recent decisions of this court. And in the light of that, it's surprising to hear an argument that the common law ought to be reconsidered, particularly where Sibthorpe 2011, Rees 2015 are both very recent decisions of this court. Both, I should say, critically decided after the introduction not only of CFAs but also DBAs.
Is that right in relation to Sibthorpe? Sibthorpe's 2011.
2011.
And Lasco was 2012.
2010 is the introduction of the legislation in respect of DBAs, though I don't think it was yet in force. I simply say that because you can see, insofar as it's relevant to the public policy landscape, both DBAs and CFAs were in the offing at the very least. When Sibthorpe was decided, when Rees was decided, they're both fully in operation. So it's not even as if Candey can say on this appeal, well, there's been some sort of change which requires the Court of Appeal to look again at this situation because statute has been modified in some critical way. It hasn't. Things are exactly the same as they were when the Court of Appeal last considered this point. In fact, for reasons I'll come to shortly, statute doesn't help Candey's position. It makes Candey's position worse because, as I think the court has itself observed, in the course of argument, the legislature has had the opportunity to revisit the common law. It's obviously alive to the common law because the Solicitors Act says in terms that it doesn't authorise the acquisition by solicitors of causes of action. So legislature has had the chance to look at this area and has intensively done so, but despite that, there's been no change in respect of assignments. And in fact, if there is anything in this appeal at all, what it's really inviting you to do is to ignore the legislation entirely and to create new judge-made rules in respect of the way in which solicitors can agree their fees. And more than that, rules with a very toxic effect. And if you take assignment as a practical example of what a solicitor could do, if you were to find for Candey in this appeal, the solicitor takes an assignment, obtains after the event insurance so that they're immune from adverse cost consequences. The regulations that tightly manage CFAs and DBAs are inapplicable, but it's not just those regulations, it's also the Solicitors Act which would be substantially inapplicable because now the solicitor is its own client. It's not just the Solicitors Act that would be inapplicable, but it's also large parts of the rules of professional conduct, because if one thinks about the rules as they now are in the latest iteration in respect of solicitors, there's a you and the court, and there's a you and your client. And certainly the you and the court provisions would still be applicable in the same way because the solicitor would be a litigant, but the you and your client rules would have no impact whatsoever because the solicitor no longer has a client apart from themselves. So what you're being asked to do is jettison the rules in respect of CFAs and DBAs altogether, because assignment gets around them. So a critical feature of, let's call it what it is, consumer protection, falls by the wayside. All of the own fees assessment provisions in the Solicitors Act go as well. So the client, the true client, is in effect vulnerable to being charged whatever the solicitor wants. The only possible protection being a complex argument about implied terms, and who knows where that would go. But also the solicitor has, well, I would say no, I won't quite go that far, but many fewer professional duties towards the client than would otherwise be the case, because the client is merely in receipt of potential distributions at the end of the litigation. And those are the deeply unattractive consequences of revisiting the rules in the way that my learned friend asks you to do. If one thinks for a moment about the authorities dealing with public policy and precedent, so take Fender as an example. I won't take you to it only because vividly it's the authority that deals with the unruly horse, that expression which is so well known. What you're really being asked to do is to take a view on the hoof about all of these things. Bit of a pun, not intended. But you don't have the SRA here, you have nobody to direct you on what the consequences would actually be of doing all of this in respect of the consumers of legal services. And it's supposed that the three members of this constitution are able to form a developed view and change the law simply on the basis of this appeal. And you can see that even if it wasn't for precedent, that would be a deeply unattractive way to proceed, and certainly isn't the way in which the court should proceed. That's what I wanted to say by way of introduction, but I would also say that that disposes of this appeal without going any further. In a nutshell, I need say nothing else, because not only does precedent bind you, but also logic and good sense not to revisit 250 years of public policy. So that's point number one. Point number two is to visit what lies behind the public policy preventing solicitors from having an interest in litigation, and particularly what lies behind the prohibition on assignments, because I say that they're not quite the same thing. There's some distinction to be drawn, and even if CFAs and DBAs have intruded to some extent on the ability of a solicitor to have an interest in litigation, what they haven't done in any way is seek to impact upon the damage that might be caused in respect of own client conflicts. What do I mean by that? Well, if we start with the classic sort of Trentex position, if I can put it that way, why is there a bright line rule in respect of solicitors not being able to enter into conditional or contingency fee arrangements. I should rephrase that. Why is there a common law rule to that effect? The answer is that there was always a significant concern that it would improperly influence the solicitor. In other words, what the solicitor might do is in some way abuse the conduct of litigation in order to obtain an advantage for themselves. And the damage that would be done in those circumstances would not be so much to the solicitor's own client, it would be damage to the opposing party and also potentially damage to the system of justice. It would offend against the rules of the court. With assignments, it seems to me there's something else in play. It's also grappling with the solicitor's duties to their own client. And to make that point good, it's informative to look at just one or two of the authorities that give rise to the rule in respect of assignments. If we could start, please, at Wood, which is in the authorities bundle at tab 10, page 39. And you can see from the head note at page 39, if we just read the beginning of it, beneficial contracts and conveyances obtained by an attorney from his client during their relation, as such and connected with the subject of the suit being also liable to the charge of champity decreed to stand as security only for what was actually due, and purchases by the attorney declared a trust. So one can see immediately that what this is dealing with is a solicitor acquisition situation, squarely on all fours with the instant case. And what I want to show you is the justification for the court finding that there was a public policy objection to the attorney doing so. If we turn over the page, please, to the judgment of the Lord Chancellor, paragraph 123, which is halfway down the page. This is a case of great importance with reference to persons standing in the relation of attorney and client. And if my lords and my lady count down another 1, 2, 3, 4 lines, you can see the words "I may infer" that this deed would give the defendant a benefit of some amount, regarding it as an agreement executed between attorney and client. It could not have stood in a court of equity. It could not be enforced. And one has to then look at the logic behind it. If you go to page 41, page 41, and look about 10 lines up from the bottom, the inset paragraph begins the cases in print that have reference to this subject. And if my lords and my lady look after the names of the various cases, you see the words laid down as clear law that no attorney can take anything for his own benefit from his client pending the suit, save his demand. And I add that, as a guardian cannot take anything from his ward pending the guardianship, or at the close of it, or at any period until his influence has ceased to exist, the obligation upon an attorney to refrain from taking an extraordinary benefit is at least as strong. And that analogy that's drawn in respect of guardianship, it is an interesting one. It's plain that what those words are referring to is the influence of the solicitor over his or her client, and the risk of some sort of improper influence being used to thereby take the cause of action or some other property. In fact, what it's grappling with is what in the modern day would be thought of as the no profit and the no conflict rules, whether one is thinking about trustees or trustees purchasing assets from the trust, or directors taking maturing business opportunities from the company that they direct. It's dealing with equitable fraud. It's stopping a person in a fiduciary position from benefiting from that position. And so that's certainly, unlike what one might call the classic Chancery cases, which are more concerned with effect on the opposing party, in assignment cases there is also a powerful consideration about the effect on one's own client. If we go over the page to 42, you can see, in fact, from the top line, the danger from the influence of attorneys or counsel over clients while having the care of their property. And whatever mischief may arise in particular cases, the law, with the view to preventing public mischief, says they shall take no benefit derived under such circumstances. And it follows that one needs that bright line rule, because just in the way that the intentions or motives of a fiduciary don't matter, one doesn't investigate whether the solicitor is acting honestly or dishonestly with the best of intentions or otherwise. There is simply a prohibition in taking the assets which are the subject of the suit. If we go on to the decision in Simpson, tab 11, which is the next in order of time, so we're here in 1857. It's exactly the same point. It's another solicitor case. And all I need do...
Sorry, can you give me the page?
I'm so sorry. The authority begins at page 44.
Yes.
And I think my lords and my lady might want to just read the short head note so you can see what it's all about. And although nothing turns on it, the facts are particularly interesting, because you can see that what this case was about was deprivation of a set-off by virtue of an assignment to a solicitor, which is a critical feature of the incident case. Nothing turns on that, but I mean, it's interesting just to see the facts of it. Just before I go to the reasoning, I just invite my lords and my lady to see opposite the bottom hole punch that you can see rule applied, Pitman and Prudential Deposit Bank, 1896. Pitman is a Court of Appeal decision. So Simpson is applied in Pitman, and that's the first of the Court of Appeal decisions. And you'll see some quotations from Pitman when we come to look at Sibthorpe. And I can show you just a very short extract from the reasoning, which is page 47. And if my lords and my lady look 1, 2, 3, 4, 5 lines up from the bottom, there is a reference to Wooden Downs in italics, which is the authority we looked at in the last tab. Considering the relation in which the attorney and client stand to each other, it would seem, as was said in Hall and Hallett, to be against the policy of the law to permit such a dealing by an attorney with the subject of a suit of which he has the conduct as the attorney, whilst the case is still undetermined by judgment, as that which is now in question before us, whatever might have been the case had the purchase been by a stranger. So once again, the reasoning is not based on, or at least not simply based upon, the impact on the opposing party or justice. It's about the relation between the solicitor and his or her own client. So I make one important observation about that. It's all very well for my learned friend to say, well, the legislature has made itself comfortable with certain forms of CFA and DBA, But what that does is not grapple in any way with the problem of how a solicitor who already has conduct of proceedings on behalf of his or her client in a fiduciary relationship with that client. So not at the outset of consultation, where I accept that it might well be possible for a solicitor to obtain by assignment a cause of action, because at that moment in time there is no existing relationship. But once the relationship is formed, there is an existing retainer, there are fiduciary duties in play. How does the solicitor then acquire the property which is the subject of the fiduciary relationship? And
just so as I'm clear as to the point you've just made, I think I have understood it, but the point you've just made is that at the point where solicitor and client meet, there is no fiduciary duty owed by the solicitor to the client.
Yes.
And the reason is the one that was identified by Lord Newburger in a case called Motter, which is that self-evidently at that point in time the solicitor is acting in his own interest, or her own interest.
Exactly that.
In negotiating the terms of the retainer.
Yes.
But once the retainer is entered into, it is otherwise, because from then onwards there is a fiduciary duty owed.
And the solicitor has to suborn his or her own interests to those of the client. That's
Yeah.
exactly right.
Yeah.
So it's not right, as my learned friend did a number of times, to categorise this appeal as about whether a solicitor can obtain an assignment of a cause of action. A solicitor is in exactly the same position as a stranger, if I can put it that way, providing the trend test, if I can call it that, is satisfied. There is no difficulty with a solicitor obtaining assignment of a cause of action. But once the relationship is up and running and there are fiduciary obligations, the position is wholly different. And it's really that point that would need to be answered so as to achieve any success in this appeal. Leaving to one side issues of precedent, one would have to find a convincing reason to say that that imperative, which was found by the courts 250 years ago, and is a feature of modern jurisprudence, I mean on a day-to-day basis, because it affects company directors, trustees of trusts, senior executives, has in some way changed. But it hasn't, and it's an area where one really does need to have a bright line rule and some regulation, and that's what the common law does. So that too is an answer to this appeal, which Candey can't overcome. Can I go next to my third point, which is about statutory modifications? Is statute the answer? Funnily enough, both parties to this appeal say statute's the answer. My learned friend says it's the answer because actually what it shows you by analogy is that, and I hope I don't do his submissions an injustice by saying this, but anything goes when it comes to fee arrangements. I say it does the very opposite of that, and actually it shows you the limits of what is permissible. But I also want to make one further point. What my learned friend seeks to persuade you of is that in fact the arrangements fall in substance within permissible DBAs, if I can put it that way. I think I broadly use the language that he uses. That's not right, and I need to show you why that's not right. In order to do that, could we begin, please, by going to the assignment itself? It's tab 11 of the core bundle. It's not, of course, always easy to identify what a DBA is. Indeed, in Lex law, which you were briefly shown, I think Lord Justice Coulson said that the DBA regulations were not the drafter's finest hour, and I think that's certainly right. But one can say this, I think, with some clarity. What conditional fees are about is a solicitor receiving an uplift on the amount that the solicitor charges. So in other words, the basis of calculation is the solicitor's fee. What contingency fees are about is the amount that is recovered. So the basis of calculation is the judgment sum. And that, I think, is a distinction that nobody could quarrel with. If we look at the distribution of recoveries, which are clause 3.1b of the assignment, what Candey get is essentially double costs plus a number. Double the amount of legal costs they've already incurred, double the amount of costs that they will incur in the future, plus the other litigation hourly rate costs, which are also their costs, but quantified. What then happens is that there is a cap. So if and insofar as that would be more than 50% of the recoveries with a little bit of tinkering around, then Candey can't recover more than that. But the essential feature of the way in which Candey's remuneration is calculated is based on their fees rather than what is recovered. So if this is anything, it's a CFA, not a DBA. It's a conditional fee agreement, not a contingency fee. It's a CFA with a cap, and CFAs with a cap are permissible, and one sometimes finds them. It just so happens that the cap is calculated by reference to a percentage of the sum that is recovered. Now, once one recognises that this is a conditional fee and not a contingency fee, we're not comparing it with the regulations in respect of DBAs. We're comparing it with the regulations in respect of CFAs to see whether in fact Candey do better under this than they would do were it a lawful CFA. And the reason why we do that, just to come back to some observations made by my Lord Justice Arnold, is that if one is trying to decide whether this is trafficking in litigation, in other words, this is making an impermissible profit, well, on my learned friend's case, it's not, because Candey recover no more than they could in fact have recovered if they were lawfully complying with the legislation. But if that's not right, if they're doing better than that, then it starts to rather look as if, even if there wasn't a bright line rule in respect of solicitors, actually Candey are engaging in avoidance of the legislation. They're doing better than they would have done if they'd entered into a lawful CFA. And the reason why I've explained quite carefully why it's a CFA, I think, will be evident, because CFAs are capped at double one's fees. You've seen the legislation, I think, already in my learned friend's submission, so I don't need to waste the time by going back to it. But this is not capped at double Candey's fees, because what Candey get, as well as double their fees, are the other litigation hourly rate costs. They get £100,000 on top. So this would never be, if this had been lifted and placed into a compliant CFA structure, the fee arrangements would never have been compliant with the CFA regulations.
Well, that's why I was asking about 125,000, because it's all very odd and not explained. Because on the one hand, they recover the litigation hourly rate costs, 100k, but on the other hand, you've got this 125,000, which cuts in before you start calculating the cap.
Well, Lord, I think there might be two ways to interpret 3.1b. And I must confess, the way I had interpreted it, I'm happy to debate it, but the way I had interpreted it was that actually the 125,000 goes to Candey. So it's then 50% of the remainder. So in other words, you take off the ATE premium, and the distribution for that is 3.1a. Mm-hmm.
Yep.
3.1b, Candey get their hands on 125,000 in any circumstances, and then there is a cap at 50% of the remainder.
So you say the effect of it is to reduce the ceiling, or
Yes.
lower the ceiling.
And if in fact the 125 had been 100, then you could see that really would make sense, because it would read nicely with the other litigation hourly rate costs. It would make complete sense, because what this seems to be seeking to do is to make sure that Candey get their costs for what they did in the county court, really regardless of what happens in the existing proceedings, providing there is enough money that is recovered, they get those anyway. It's just the curious thing is that it says 125 rather than 100. But I think that because the other litigation hourly rate costs are an issue, my interpretation of it is actually the right interpretation, that Candey are getting more, not less. So even if this was in substance a DBA and not in substance a CFA, I'd also say it's in breach of the DBA regulations, because actually Candey potentially get more than 50%. But I say it's not a DBA. It's not a CFA or a DBA in any circumstances, but I'm talking here about whether in substance the remuneration arrangements fall within permissible CFAs or DBAs, and I would say they don't fall within either. But in any event, it's CFA territory that we're in and not DBA territory. So even had there not have been a bright line rule in respect of solicitors, if we were having to debate whether it's having some sort of legitimate proprietary interest or interests of justice or facilitating access to justice, however one wants to articulate it. They are accept quite different things in the authorities, but however you articulate it, that something has gone wrong here whereby Candey are actually making more profit than they would have been able to do were these compliant CFA or DBA arrangements, and that really does give rise to an issue of trafficking in litigation.
Ask you, on your proposed construction of this, what seems to be missing is any reference to the 125,000 being paid out under the waterfall. Because first goes the IPT tax, then the sum, which is up to a maximum of 50%, and then the balance to the assign all. There's no stage of that process where the 125 gets paid out to anybody.
But it isn't the answer that they shouldn't ask the court questions, my lord. It
You
seems
can ask
to
it
me
rhetorically.
it seems to me, my lord, that the answer is that actually one doesn't need that because it is a waterfall. In other words, you get to see the balance is paid to the assigner. Everything that's left is in Candey's hands. There doesn't need to be a payment because Candey simply hangs on to.
So your construction is the answer to the question I posed this morning as to why one doesn't see provision for 125 being paid out to Mr Farrar.
Exactly that. Exactly that. And it's the absence of that that means that my construction, I say, is the right one. I'm not suggesting, my lord, that it's a model of
It probably
good.
doesn't matter. I just don't see how it works, though, on that basis, because what we're talking about is recoveries, and then it talks about what out of those recoveries are paid out at A and B. Then the balance is the balance of the recoveries.
But is it the assumption that the recoveries go to Candey as assignee in the first place, and therefore it's just about distribution, and
Yeah.
Candey just distribute
Yes.
Yes.
But unless you,
what they're
well,
told to?
it probably doesn't matter.
Maybe.
And Candey will have a judgment, assuming it litigates, wins. Candey has a judgment in its favour. The money goes to Candey.
Yeah.
And what 3.1 is doing is simply requiring Candey to distribute, and there is an order of events. And unless anything is expressly going out, it stays in, if I can put it that way. And I do say, my lord,
It's interesting, isn't it? I mean, actually, 3.1b, it doesn't actually say to whom that sum is to be distributed.
None of them do. Nor does A.
well, But there is no.
No, it doesn't.
But there is no distribution under B, because Candey's already got the money, so it doesn't distribute to itself.
Well, look at the first words of the clause. The recoveries will be distributed by the assignee in the following order of priority, continuing down the list until the recoveries are extinguished. So what that's saying is you've got a pot of money and you pay it out in this order.
Well, B is...
So you first of all pay out the insurance premium, so you knock it down by that. Then you pay it out by the amount calculated in accordance with B. And then you pay all the rest to the assignor.
Well, I just read B as being an exclusion from C. It's just the method of calculating C.
But then so is A.
I agree with that, but there would never be a
why doesn't it just say? Well, anyway.
Well, because it's shockingly drafted is, I think, the answer.
But I mean, you have to agree with this, isn't it? There is nothing in that waterfall which provides for a distribution of 125,000 to anybody.
Well, I agree with that, but I would make the observation that that's because someone can't distribute to themselves.
But that's the case of the whole of B.
It is the case of the whole of B. I agree. But what suggests that Candey were hanging on to the 125 is the other litigation hourly rate cost, because it was clearly intended that at least £100,000 would go to them in respect to the Central London County Court litigation. So why it's jumped to 125,000, I don't know, but there is some similarity between those numbers, and it seems to me likely that that sum, without enhancement, was going to them in respect of that litigation.
You can postulate a rationalisation, and I emphasise the word postulate, that it's 100% uplift on the costs of these proceedings, but only a 25% uplift on the county court proceedings.
Yes, although then it is slightly odd that there isn't the same 25% uplift in respect of the conditional fee. Yeah. But more than that one can't say. But anyway, I don't read it in the way that my learned friend reads it. I read it as actually Candey getting more than 50% because of the other litigation hourly rate costs. So,
but they're included within the 50%.
Well, that depends on how you read B.
Well, it's quite clear. It says plus 2 the other litigation hourly rate costs.
Well, that's the conditional fee element.
The second part of that clause is only directed at the cap.
Yes, but the question is, when it comes to the cap, is the method of calculation, as my learned friend would suggest, which is you take what has been recovered, you reduce it by the amount of the ATE premium, you reduce it by the 125,000, you divide it by 2, and that's what goes to Candey? Or is it as I've suggested, which is that from the recovery, the ATE premium is discharged, Candey take 125,000 for themselves, or rather hang on to it, and then the remaining amount is divided by 2, so that half goes to...
I just don't see how that even remotely arguable is. There's just absolutely no indication that Candey get the 125.
They've already got the 125, my lord, that's the point.
Well, that they keep the 125
yes.
Then,
because there's nothing here that says they distribute it.
Well, you've got to look at what's distributed, and then the balance is distributed to the assigner. So unless it says that something else is distributed, it goes to the assigner.
Well, my lord, I wouldn't agree with that, because right hand doesn't distribute to left hand. So the only distribution which is taking place under 3.1, other than possibly discharge of the ATE premium, is a distribution to Mr Farrar. And the way that this works is whatever's not distributed just remains in Candey's coffers.
Well, I'm sorry, I just don't see that. Given C, the balance to the assigner. It's saying anything that's not dealt with by A and B goes to the assignment.
I agree with that, my lord, but the point is B saying that the 50% is applied before you deduct the 125,000 or after?
But there's nothing to say that that the 125 is distributed. Anyway,
this is so...
To some extent, this is not your problem.
No.
This is a Candey agreement, and any of these confusions, it seems to be, which there undoubtedly are, only go to demonstrate the difficulty with this sort of arrangement.
Well, my lord, not my problem for another reason, which is that if you are with me, and this is in fact a capped conditional fee rather than a contingency fee, then if and insofar as you need to go further than the bright line rule and look at the extent to which Candey are going beyond what the CFA regulations would permit in terms of their remuneration, then on any analysis they are, because as well as obtaining double their fees, they get £100,000 on top. So that's the critical point from my perspective. But one could debate 3.1b, I think, at some length, and I understand my lord's view. So where we're left with is that even if one was applying a trend text or a Sibthorpe type analysis, the way that my learned friend approaches that is to say, well, look, in substance, actually what this does is it has the same effect as something that would be permitted by the legislation. In fact, the answer is it doesn't. It goes further than that. So for that reason alone, even if there wasn't a bright line rule, it would be seriously problematic.
Well, we know it's not something that would be permitted by the legislation, because the legislation says that only things which comply with legislation are valid.
Yes.
I don't, it seems to me we're sort of tying ourselves in knots with trying to work out whether it comes within the legislation or not.
Well, I don't think anybody is suggesting it comes within the legislation. I think what my learned friend is saying, if I understand it correctly, is that in terms of its financial impact, it's doing the same thing as would be permitted under the legislation. So he would say Candey are only taking what they would be able to take if they had entered into a lawful conditional or contingency fee arrangement. And he makes that point to try and grapple with the Champerty issue if and insofar as there's no bright line rule, as I suggest there is and should continue to be. Now, whether that's a good point or a bad point, I say it's a thoroughly bad point, but I'm just meeting it head on by pointing out that in fact it's not correct anyway. So it's not my point, I'm simply meeting the point that's taken against me. The fourth issue I want to deal with is whether the court can reappraise the public policy reasons for prohibiting solicitor assignments. Well, I've already made the observation, and I'll show you in a moment, that it's the ratio of a number of Court of Appeal decisions and indeed recent Court of Appeal decisions. So the first problem, an insurmountable problem, is precedent. And to say, well, it's a public policy point and public policy is capable of moving is not an answer to that. That the fact is this court is bound by its own decisions. One can perhaps postulate extraordinary circumstances where it might be possible for this court to depart from one of its decisions based on public policy. So if, for example, there was a 19th century decision which prevented a particular benefit from accruing to women, was plainly discriminatory, that the whole landscape of the world had changed, there was no appellate authority which lay immediately in the way of revisiting it, and public policy was so obvious that the court could look again at that situation. Maybe, I put it no higher than that, the Court of Appeal might be able to look at the situation again. But we couldn't be...
Well, then you'd say the laws changed by virtue of the Human Rights Act.
Yeah. Or whatever. You would presumably have to find a source to obtain the change, whether that would lie in the Human Rights Act or perhaps in the Equality Act, or something would have had to have changed that would allow the court to do it. I'm not saying there might never be circumstances, but they're not the sort of circumstances in this case where what essentially you're invited to do is to form a personal opinion that the legislature must have intended the law to move on without there being any support in any authority or any parliamentary debate or any legislation, just to form a personal opinion and to allow that to provoke a change in the common law. That would never be acceptable. So that plainly is a real problem. Indeed, I would say fatal to this appeal. Indeed, other constitutions of this court have made exactly the same point in respect of the common law in this area. And I'd like to show you that, if I may. If we begin with the decision in Factortame, and that is at tab 18, page 244.
You say there were other Court of Appeal decisions before Factortame that are ratio in relation to this issue, but you're going to find them in Factortame, are you?
I'm in the course of showing you essentially Factortame, Sibthorpe and Rees.
Yeah.
You will see all of the other references to the earlier decisions, and that's why we haven't included them.
Okay.
Not least because they predate CFAs and DBAs, so
Yeah.
it is just easier to look at the modern landscape, it seems to me, to see that there's no change. So if we start with Factortame and dip into the judgment of Lord Phillips at 36. Now, I should say Factortame is not a solicitor case. What Factortame was all about is whether Grant Thornton, who were providing litigation services, should be treated in terms of their fee arrangements as if they were solicitors. So it touches closely on the issues as they relate to solicitors. Paragraph 36, please. Could I invite the court to read that? So the reference to analogous situations is obviously important, because one can see that even if the legislation doesn't expressly deal with a particular scenario, one can draw the analogy and say, well, that's what's permitted, and anything else, even if it falls wholly outside the legislation, isn't. If we turn on, please, to 46, page 266. If I could invite my lords and my lady, please, to read that paragraph. And one can see the obvious importance of the last four lines there. There is the Court of Appeal saying in terms that because there's been intervention by Parliament in this area, there is simply no scope for any finding that the common law has developed in any way. And finally, please, paragraph 61. And one can see from 61 that Lord Phillips describes the ratio of the Court of Appeal decision in Awad, that also being that there was no scope, to use his words, for the court to hold that the common law permitted conditional fee agreements that did not conform to the requirements imposed by Section 58. So my summary of factor tame would be that the scope for the court to revisit the common law, specifically in this area, in the light of statutory intervention, is zero. And you would have to be persuaded by Candey that that's wrong and that you should depart from this decision before they could get any traction on this appeal at all. If we could turn next, please, to Sibthorpe, tab 20, page 289. Another solicitor case. And if we could start, please, at paragraph 17 in Lord Newburgh's judgment. I ask you to read, in fact, if I could ask you to read 17 and 18, because what it does is summarise both Wallersteiner and Pittman. And then at 26 is a summary of and quotation from Awad. And it's a classic quotation that one finds in some of the other authorities. So if I could invite you, please, to read 26, that will tell you what you need to know about Awad. And you can see from 26 that the summary given by Lord Phillips in factor tame of Awad is, as you would expect, absolutely correct. The decision in Awad is there is no scope to enlarge the common law. If we turn on, please, to 35, paragraph 35, opposite letter D, you can see the argument being made to the Court of Appeal that based on factor tame and Giles and Thompson, I should say, but neither of which are solicitor cases, it is said on behalf of Ms. Morris that there is no longer a strict principle such as Lord Esher laid down in Pittman's case and the Court of Appeal affirmed in Wallersteiner and Muir. It is further said that the correct approach is now to look at the CFA in the round and decide whether it would undermine the purity of justice or would corrupt public justice, a question to be decided on a case-by-case basis. So you have exactly the same argument being made here to the Court of Appeal in Sibthorpe as is made to this court in the instant case. And that's why the decision on this point, you will see in a moment, is the ratio. Paragraph 37, with the sole exception of the tie trading case, there seems to be no support for the application of such an approach, where the alleged Champertus agreement is entered into with a person who is conducting the litigation in question or providing advocacy services in connection therewith. Such agreements have always been treated as a special category, etc. And I should say no one has given tie trading to you because it is universally accepted to be wrong. And there are a number of subsequent Court of Appeal decisions after it which are, will say in terms that it's wrong. Lord Neuberger doesn't go quite that far, but you'll see what he says in a moment. If we go to paragraph 38, despite Mr. James' submissions to the contrary, I believe that this view also accords with that of this court in Factatame. Lord Phillips, MR's citations of Lord Justice Buckley's observations in Wallersteiner and his reference to Awad's case undermine the notion that he was intending to depart from the principles in those cases. 39 deals with tie trading. Could I just invite you to read that, which will explain why no one troubles you with tie trading. And then I suspect my lords and my lady will already have read 40 and 41, which are the essence of Lord Neuberger's judgment. So Sibthorpe 2 tells you no scope to interfere with the common law, and then we turn to Rees, which is the most recent of the authorities, and that's tab 21, page 307. Rees again is a solicitor case, and it's a solicitor case where the argument was that the nature of the arrangements fell outside of CFAs that were permitted by legislation because the solicitors were not solicitors on the record, and that issue doesn't matter on the facts of the instant case, but the reasoning does. If you turn, please, to paragraph 31 in the judgment of Lord Justice Lewison, we just need to look at the first three lines to see where the argument's going. Mr. and Mrs. Rees argued that even if the retainer agreement fell outside the scope of Section 58, I just pause to say that's because Gately Waring had said we're not on the record, so it's just not caught by the legislation at all. It was unenforceable at common law on the ground that it was a Champertus agreement. The judge rejected that argument. So what the Court of Appeal are considering is whether the judge below was to reject the argument that it was Champertus for common law reasons, and if we look, please, at paragraph 33, could I invite the court to read that? And my lords and my lady will see at 34 is the same citation from Awad as we've already seen by Lord Neuberger in Sibthorpe. And the ratio, at least of this part of the judgment, at paragraph 36, is that it doesn't help a solicitor to argue that the agreement is one that falls outside of the legislation altogether, because in those circumstances it's not been sanctioned by Parliament, the common law swings into play, and it's unenforceable.
It's also interesting that what is repeated again is Lord Justice May's reference to perceived to be public policy.
Yes.
I think that's, an important point of how does one actually discern what this public policy is, or said to be.
Well, there's no difficulty in discerning what public policy is in respect of assignments to solicitors, because there are so many authorities which indicate that it's impermissible.
Forgive me, I meant what it has changed to become.
Yes, the other way round, I agree, is a very considerable difficulty for this court to formulate what the new public policy is would just be impossible for reasons I came to earlier. I mean, it could well be that I could be in front of a court of appeal where every member of the Constitution has a firm view that assignments to solicitors are a great idea, but it wouldn't matter one bit. It's not a reason to revisit the common law with the unintended consequences that might follow. So for all of those reasons, there are multiple Court of Appeal decisions which stand in the way of any attempt to revisit the common law. Precedent tells you that it's not possible to do that. And you would have to find some sort of way unexplained to you at the moment to depart from those authorities, two of which are very recent. And then I have one final point, which is assuming I'm wrong about everything else. You can interfere with the common law, you're inclined to do so, should you? Does this supposed assignment in fact improve access to justice? The judge was very sceptical about that below, and he was right to be. And there are three reasons why, in fact, the assignment in this case was offensive to the interests of justice. The first of them I've dealt with already, which is conflict. In all of these sorts of cases, is the court to carry out an investigation as to whether there's been some sort of undue influence, whether the solicitor's acted in breach of fiduciary duty? Is that now to be the precondition for the enforceability of the assignment? And of course, one has to view this not just from the perspective of the solicitor's own client, but also the opposing party. When the opposing party faces a costs application at the end of unsuccessful litigation, what arguments may flow in terms of enforceability? Well, the reason why one needs to have a bright line rule is so that these sorts of conflict type arguments, if I can call them that, can't be deployed at the end of litigation. So that's the first reason why it would be wrong to interfere with the long-standing rules of public policy. The second reason my lords and my lady will have well in mind, which is the avoidance of the consequences of bankruptcy. And it's not an answer to that to say that there might be other remedies available under the Insolvency Act. What this court is being asked to deal with is public policy, and anything in public policy which would allow a litigant in effect to avoid the consequences of being a litigant by passing on the burden to his or her solicitor is something which ought to be prohibited. The third point, which I've dealt with in my skeleton, and I don't know whether the court needs any particular assistance with it, is the avoidance of set-off, changing priorities. I can probably do it quite shortly because you have all of the references in my skeleton, but the answer is this. As you will be aware, companies controlled by Mr Miller had a substantial judgment from Central London County Court. He has, unsurprisingly, as everybody must have predicted, taken an assignment of the judgment debt. So it follows that what he would inevitably want to do in litigation is set off what he is owed by Mr Farrar from anything he might ultimately be ordered to pay. Although Candey prays in aid a solicitor's lien, the authorities are clear in almost all circumstances the lien operates after set-off, not before. And I've given you all of the references to the authorities in that respect. I don't think it's arguable, and my learned friend rightly hasn't sought to argue I'm wrong about that. So in the circumstances, whereas at one point in time, what Mr Miller would have been able to do is enjoy that set-off, what the assignment avoids is his ability to do so, as surely must have been part of the intention behind it. And it follows from that although one might say, well, Mr Farrar's access to justice has been improved, in the process Mr Miller's access to justice has been very heavily diminished, and that's not something the court should countenance.
I understand your first reason, conflict. Your second and third reasons seem to me that those objections would also apply to an assignment to a non-solicitor, wouldn't
they? Well, my lord, the reason I just hesitate before I answer that is that, of course, the non-solicitor, the professional funder, for example, would have to consider quite carefully all of the circumstances and might be rather less willing to enter into an assignment if the picture didn't look particularly attractive.
But it's a matter of principle. An assignment to a non-solicitor would also avoid bankruptcy consequences and would avoid set-off.
As a matter of principle, I accept that's correct.
Yeah.
Yes, I agree with that.
So number one's the big point, isn't it?
Number one is the most critical point, and also, of course, has a great deal of support in the authorities. My lady, my lords, unless I can assist you any further, I think that's almost my 3:30.
Thank you very much, Mr. Cohen. Yes, Mr. Hagg.
Thank you, my lady. A few very short points by way of reply. My learned friend makes a great play about the nature of the fee agreement, whether or not the assignment is in fact a CFA in disguise or a DBA in disguise. Our position is it is neither of those. It is not a fee agreement. And it is one thing, I think, to say or to allow under the common law a CFA which is not allowed under the statutory provisions. It's a completely another thing to allow under the common law an assignment which resembles a CFA. There's two different things. So,
yes, but this wasn't Mr. Cohen's point. Neither of you are saying that this is a CFA within the rules, and nor is either of you saying it's DBA within the rules. Mr. Cohen's point was, to the extent that there was an analogy, the true analogy was with a CFA and not with a DBA.
obviously, I accept that.
Okay.
My point is that it doesn't matter because neither of them are CFAs or DBAs, and so so the authorities which he took you through in relation to what you can or can't do under a CFA are, I say, neither here nor there.
But are you accepting that the analogy is more with CFAs rather? You're not accepting that. Right.
I'm not. He's only right to the extent that when one looks at the assignment, there is a base level which refers to hours, but all that is doing to the hours done. But all that is doing is explaining how the distribution is made. It is a way of, it's a method of calculating.
But if the cap never cuts, then it's 100% successful.
But the way that I would read it, my lord, is to say that the primary operating provision is a 50% cap of the damages, which is equivalent to the DBA. And the intention was that it mirror the DBA as much as possible. And so the 50% cap is the 50% cap on recoveries under the DBA is what you see in the assignment.
But suppose you never get to the 50%, then the way it operates is a 100% success fee.
But yes, I agree.
And in that regard, it's totally akin to a CFA.
Yeah. I certainly accept that. I mean, that's just the reading of the distribution clause. Yes, absolutely. But the point I make in relation to that is when one looks at the authorities, there's only so much one can draw from any of them as to the nature of the fee agreement, because this isn't a fee agreement.
But you do say at paragraph 42 of your skeleton argument that this agreement falls in substance within the limits placed on DBAs.
I think what I meant is that in relation to the recoveries that one makes under it, this is more akin to a DBA than a CFA.
Okay. This is your effect point.
Yes. So it was clumsy language
because of the 50%.
Yeah, because of the 50%. But that's all it is. The other points were in relation to statutory interpretation. I think I'm not going to do any better than what I said beforehand. And my lady, in your lordships do have the point that statutory interpretation, or rather the common law, is often defined by what parliamentary legislation has put into place. So, for instance, if Parliament says X, then the common law can simply be informed by that. And I can't say any more than that. So when you are looking at what Parliament intended, one looks at the statute. When one then tries to infer what the common law might be, the common law is permitted to be informed by what the statute says.
Do you accept that the exercise you were inviting us to do is an exercise that was pretty much exactly what was depreciated in certain of the Court of Appeal authorities we've just been shown, namely to say that to say that public policy has changed by virtue of the statute, so that things that fall outside the statute can be said to be lawful when they would not otherwise be.
The cases that you were taking through were very specifically in relation to the validity of fee agreements. And so what all of those cases were saying, that if you have a fee agreement which doesn't comply with the regulations, then that is improper, and therefore there is no scope in public policy to allow those fee agreements. So those are the cases. I'm not saying that. I'm saying this is not a fee agreement, and one has to see whether or not the policy changes which have been obviously made by the statute can be then imported into the assignment.
They're considering it in the context of the law of Champathy.
They are, yes, absolutely. But what they're also saying is that Parliament has specifically intervened in fee agreements for the CFAs and DBAs, so you cannot have a CFA or DBA which falls outside those. But even then, when one looks at Sibthorpe and when one looks at I'm forgetting its name now.
Rees.
No. The Zuberi case, the Lex Law case. The Lex Law case. There you have two examples where even despite that, the courts have found those agreements not to be champitous. So Sibthorpe was slightly different because they said it wasn't champitous at all. But in the Lex Law case, the DBA was significantly altered and included the termination provisions in the DBA. So the DBA regulations don't have any termination provisions. In Lex Law, the DBA did, and that wasn't a problem either. So the point I'm making is that, yes, Parliament has intervened specifically in those areas, but that doesn't mean in those areas where it hasn't intervened, the common law has no place at all. So when one looks at fee agreements, one has to look at what the regulations and what statutes say. But if it's not a fee agreement, well, then it's very different. And all the cases which have been cited are in relation to fee agreements which have been slightly varied, or something has gone wrong in those arrangements, which takes them outside the scope of outside the scope of the statute, when otherwise they ought to have fallen in. So my argument is that what we have here is something which was never going to fall in the scope of the statutes, and that's why all those authorities where you're not allowed to consider public policy, or public policy is defined by the boundaries of the statute, don't apply here. This assignment was never going to fall into one of those. So the cases which refer to those being the extent of parliamentary intention simply doesn't apply here. And hence I say there's a residual scope for the court to look at what the common law is. And I'd merely say the common law is what Parliament says it is. And here what Parliament says is that contingency fees and DBAs are allowed. What does that mean? It means that there is no conflict of interest in solicitors taking a share of proceeds. And if there's no conflict of interest, then what's the problem with an assignment? Which effectively, I say, does the same thing. I'm not asking the court to revise the view of public policy. What I'm asking the court to do is interpret the DBA regulations as being Parliament's expression of public policy. And if the court accepts that Parliament has said X and that means that this is what public policy is, I'm simply asking the court then to apply that to the assignment situation. So it's not a point where my lady and my lords are there making up a view about what they think public policy should be. I'm not saying that at all. What I'm asking the panel to do is simply look at the statute, look at the DBA regulations, and conclude from that that Parliament has decreed that solicitors are allowed to take shares. Therefore, there is no conflict of interest there, because the cases, again, the whole reason for not having contingency arrangements was conflict of interest. Now they're allowed a fortiori conflicts of interest don't matter.
But it doesn't say they can take shares, does it?
I take it to become an equal partner in litigation, a 50% stakeholder in the litigation.
Well, it provides for what it provides for how their remuneration will be calculated. Doesn't it?
Yes.
It doesn't provide for them to obtain a proprietary interest in the claim at all.
No, but it does mean that if they, it doesn't do that at all. No, I accept that, of course. But what it means is that the outcome of the litigation is that they are in an equal financial position as the person who's originally, in whom the litigation originally vested. That's what it is. But those were not allowed, clearly not allowed, because that would be conflicts of interest which the common law and was in place to prevent.
But what you're saying is that the effect of the statute is that Parliament now recognises that it's okay to buy and sell litigation.
Yes.
With solicitors.
Yes.
I just don't know how you can say that.
Well, not okay to buy and sell per se, but you are allowed to enter into a relationship with your client, which means that you control the litigation as a solicitor, you run the litigation, but you also have a 50%.
Why would you say you can control litigation?
Well,
the client controls litigation, the client gives instructions to the solicitor. Has that somehow been abrogated by CFA?
No, I didn't mean it like that at all. The solicitor is still the solicitor in the litigation, but the solicitor has an interest in the outcome of the litigation, a direct outcome.
Well, that's what's changed, hasn't it? Like, is that he can have a financial interest in that his remuneration can be dependent upon the outcome. That's what the statute's done.
Yes.
But it has not in any way abrogated, at least in any straightforward way, abrogated the principle that a solicitor should not be entitled to obtain a proprietary interest in the claim. And you're saying that that's how we should now interpret it?
Well, what I'm saying is the reasons why a solicitor was originally prevented from having any kind of share in the outcome was because of the conflict of interest that solicitors would have when it's.
You're asking us to find that a policy has been abrogated by something. A policy has been abrogated when Parliament hasn't gone anywhere near that issue.
Well, no, I say that by allowing DBAs at all, and by allowing solicitors to have shares, have a 50% interest in the outcome of litigation, it has. Because what it's saying is that the conflict of interest which previously existed preventing such is now gone.
Well, I think the terminology is difficult, but I think that there's a fundamental distinction, which I think keeps on being fudged by the way you're referring to it, between your remuneration for acting on a case being calculated by reference to the recoveries and actually becoming the owner of the claim.
Yeah, no, certainly. I was thinking my skeleton, I did it by analogy, but yeah, you're absolutely right, because effectively what I said is by analogy, these are two joint ventures, really. Of course, overlaying that is the code of conduct which applies to solicitors and its professional obligations to the client and to the court, obviously. But when one looks at the commerciality of it, both the client and the solicitor are joint ventures, and they will each receive 50% of an eventual outcome. So that was the inept and inexact analogy. Essentially, both parties are would receive the same outcome as the litigation. And again, stepping back from all of that, the point I was making was that why should a solicitor in that situation, with no proprietary interest in the 50% obviously, but who still has a 50% contingent interest if the outcome goes the solicitor's way, why should the solicitor not be able to take the same, or take some protective measures to make sure that should the client become bankrupt, the solicitor would have some recourse. Because otherwise, take the example of a solicitor who's worked on under a DBA for years and years and years, and in some of the larger ones, costs go into the millions. Has done that, and for reasons unforeseen or unpredicted, the client is facing a bankruptcy again, another judgment in another country or whatever, and the solicitor suddenly thinks, "Gosh, no, I've spent £4 million on this. The client's looking to go bankrupt. What do I do? Am I not allowed, as any other creditor would do, what another creditor could do, to receive an assignment?
Take out insurance.
Take out insurance. Well, insurance.
Insure against bad debts.
But no, that would, the debt hasn't arisen in this one. It's another argument. Because to me, if you could insure against, no, that would be insurance against non-payment of a debt, but the debt doesn't arise here. And what happens in this case is the client becomes bankrupt, and the cause of action then vests in the trustee in bankruptcy, and the trustee in bankruptcy decides to sell the case or just say it's not worth fighting the case or doing whatever. So effectively what is happening here is the solicitor is being denied. It doesn't have the right which other, not similar people, other parties in a situation where they would otherwise benefit from the litigation could do. And I suppose when one looks at public policy, one asks the question, well, is there any reason why it shouldn't? If there are such reasons, how does one deal with that? And the only answer we rely on is we say that the assignee should take independent legal advice. And if it does, then that meets a lot of some of the criticisms which have been raised. I'm going to repeat myself, so I won't do it again. But as I say, it comes down to whether or not the court accepts that there is an access to justice point here, namely that solicitors may be inhibited from taking on difficult cases or easy cases with clients who might be impecunious because they know that ultimately there's a risk they may not get paid.
Well, there are structures that it could be assigned to a funder, and then the solicitor could have a CFO of the funder.
Well, this was my point. If you can do it in a different way and have the same result, then what's wrong with an assignment which has the same effect?
But why not do it in the different way that is lawful?
Lawful.
Well, the answer is obviously with the benefit of hindsight, and things could have been done differently, but the way that was chosen was to take an assignment. But if the outcome is the same as my lord says, then where's the mischief?
Well, the mischief is sorry.
No, go on.
Well, the mischief is that the solicitor doesn't then become the client. That's the mischief. Is all this is aimed at.
It's an interesting discussion because the example I gave beforehand is what if Mr Candey and Mr Farrar set up their own joint venture company and that joint venture company was a separate entity and the assignment was made to that entity. Whereas in fact, yes, technically they are no longer the client because the client would become the JV, but they are both 50% shareholders in the JV and the distribution to them would be exactly the same.
We'll see you back here and to argue about that then.
Well, maybe next time. Right. One final point on the terms of the assignment itself, as to whether or not the £100,000 goes to Candey or to Mr Farrar.
You mean the 125?
125 goes to and it's the point that if the contract's going to be interpreted contra proferentum anyway, so if there's any doubt here, it should go to Mr Farrar. Our interpretation is the one that the Lordship, I think, agrees with the £125,000 will always going to go to Mr Farrar. But if there's any doubt,
But where does it say that?
well, the way that it reads is clause 1 is the insurance premium.
Yeah.
Okay, so the three sub-clauses. So 3.1 is insurance premium. 3.2, the last line, again, it's not particularly well drafted, but the last line does refer to the money going to the assignee. Only if it obtains an order or reaches an agreement. Yes, I know. But the best I can do there is say, well, that, although not particularly well drafted, that gives an indication of where the money in that clause is going. And then the balance of everything else then goes to the assignor, goes to Mr Farrar, which makes some sense. But as I say, if there is any benefit to the advantage, you'll go to Mr Farrar in all of this. Would have gone to Mr Farrar in all of this. Thank you, lady. Thank you, Lord.
Thank you. Well, thank you, Mr Hack. Thank you to all counsel and those sitting behind you for the care with which this appeal has been prepared and the very helpful submissions both in writing and orally today. I'm very grateful for that. We will be reserving our judgments and they will come out in due course in the usual way for corrections, typographical errors only, not supplemental submissions on the arguments, and I hope that we will then be able to hand them down remotely without requiring the attendance of the parties in relation either to the judgment or to any order consequent upon it.
Grateful, my lady.